Request is reasonable and will not prejudice the Assembly's case. The committee therefore directs that Mr. John Otieno shall appear tomorrow, 24th June 2020, and the County Assembly shall be at liberty to cross-examine the witness on the issues raised in the summons during cross-examination. Third, on the preliminary objection to the form of the document filed by the County Assembly, the committee notes that it would have been desirable for the County Assembly to present well-bound documents, properly paginated, to assist the committee and all parties in understanding and deliberating on the matter herein. And therefore, our secretariat will also furnish the council representing Governor Waiguru with a well-paginated document, if you so require, to help you execute your matter. Fourth, on the issue of introduction of new documents and evidence, owing to limited time available for this committee to present its finding to the Senate, the committee notes and encourages the parties to canvass this issue during hearing. And the committee shall proceed with the documents as filed and make appropriate determination on the veracity, admissibility, and propriety of the evidence in making its final determination in accordance with Rule 19 of the 5th schedule of the Senate Standing Orders. That is our ruling, and I will now guide the meeting as follows. We shall allow the opening statements because of time. We shall listen to the opening statements from both parties, 30 minutes each, and then we shall break for lunch. When we come back, we shall now have time to start the County Assembly presentation. So we shall start by opening statements on behalf of the County Assembly of Kirinyaga. Do you have anything?
Chairman, just to thank you for your very clear directions, and to put it on record that we would very much appreciate, before we start with the afternoon session, a clear and paginated copy of these documents so that we can follow the proceedings. Thank you very much.
Okay, we shall ensure that our secretariat furnishes you with the same. Yes?
Much obliged, Chairman. With your kind permission, I would begin to probably give my opening statement, and we highly appreciate the committee's findings. Mr. Chairman and the honorable members of the committee, today the Assembly is being called upon to look into the conduct of the governor of Kirinyaga County insofar as the question of good governance, the question of proper administration, the question of accountability, the question of transparency, and the question of abiding to the rule of law is an issue. Mr. Chairman, this committee has congregated here pursuant to a motion that was passed, or a resolution that was passed by my clients, the County Assembly of Kirinyaga County. Suffice to note, Mr. Chairman, that the County Assembly is constituted of 33 members, and out of that 3 members, 23 returned a positive verdict that it saw or deemed it fit to have the governor answer to these charges. Suffice further to note that out of the persons who attended the proceedings on that day, it's only 4 members of the County Assembly who abstained. Abstinence does not mean a vote of yes or a no. That means, honorable members, that the County Assembly, in execution of its mandate under Article 1, where the sovereignty belongs to the people, congregated, and out of the 30 wards present in Kirinyaga County, 23 wards felt that they have no confidence in the manner the county is being run by the governor. Honorable members, we shall be able to present witness and evidence to prove and to adduce evidence towards the charges facing the governor. However, before we get to that position, honorable members, I wish to invite the committee to move with me that we are looking at a very complex case of corruption, a complex case of misappropriation of public resources, a complex case of mismanagement of public resources. We all understand that corruption and issues of public mismanagement of resources is a complex web. The committee might be then asking itself, how is the Governor Waiguru involved in the processes of the tender? Does the governor sit in the tender committees? That might be the question that the Senate might sit to resolve at the fullness of time. But as I said, that the question of corruption and mismanagement of public resource is a complex web. We shall be calling witnesses to show and to demonstrate to this country who are the owners of the monies that the county assembly is rising up to defend, that Governor Waiguru's hearts were in the cookie jar. We have witnesses to testify that besides Governor Waiguru not sitting in any of the procurement committee, her hands were present. What am I saying, honorable members? I am saying that we shall be able to demonstrate nexus. The nexus between the conduct of the governor and the persons sitting in those tender committees. Remember, honorable members, that when this House and the National Assembly sat to legislate on the Leadership and Integrity Act, they legislated a very interesting Section 35 of the Act. And Section 35 of the Act was actually looking into or foreseeing a situation that faces us today. Which situation is that? A situation where the governor sits far away from the committees procuring the tenders or evaluating the tenders, but our hands are in the cookie jars. And what did the National Assembly do? The National Assembly legislated Section 35, which we shall be submitting on. What was that section providing for, honorable members? That even when a governor or a state officer or a public officer moves to perpetuate the abrogation of Chapter 6, when the state officer or the governor moves to perpetuate the abrogation of the PMF Act, when the governor moves to perpetuate a transgression on the Public Procurement and Disposal Act, she could be acting through the influence of others. We shall be able to lead evidence to demonstrate to the committee members that Governor Waiguru is not even cognizant of the provision of Section 30 of the County Governments Act, which provides that the governor has the capacity and the responsibility of offering leadership in the executive committee and in the administration of the entire county. We'll be able to highlight what actually administration of the county means. Administration of the county means that there must be a nexus, that the governor is not a governor executing executive functions only, that the governor must also be in charge of the administration of the county. And that, honorable members, we'll work with you in the provisions of Article 179, which designates the governor as the chief executive officer. The chief executive officer of Kirinyaga County. It then means that the chief executive of Kirinyaga County must be cognizant of how the affairs of the county government are being run.